discharged or vitiated due to non-performance, the existence or non-existence of a fact or other situations. There are 5 vitiating factors, but the one that we will be focusing on today is undue influence. Undue influence exists where a contract has been entered into due to pressure that falls short of duress. The party subject to this pressure may have a cause of action in equity set aside this contract on these grounds. It operates where there exists a relationship between the parties which has been exploited by one party to gain an unfair advantage. The traditional approach to undue influence in English law is to distinguish between actual and presumed undue influence. Where a contract is found to be entered into by undue influence, the contract will be rendered voidable at the innocent party. There are 2 classes of undue influence, which are actual undue influence and presumed undue influence. In class 1, which is actual undue influence, this requires proof that the contract was entered into as a result of actual influence. The plaintiff must plead and prove that the acts that led them into this contract amounted to undue influence. Manifest disadvantage is not required in this case. Class 2 is presumed undue influence. In class 2A, there is no requirement to show that improper influence was actually exerted. All that needs to be established is that a relationship existed which gave rise to the presumption of undue influence, and that the transaction is one that cannot be readily explained by the relationship of the parties. In class 2B, there's no automatic presumption that arises as a matter of law. The only thing that needs to be established is that one party placed their trust and confidence in the other to safeguard their interests. There is a rebuttable presumption in class 2, where the party excused can rebut the presumption by showing that the other party has exercised their free will in entering this transaction. It is usually shown by showing that the party was fully aware of the risk involved and/or had received legal advice before entering into this transaction. In Malaysia undue influence, it is governed by the Contract Act of 1950. Section 16 is the main section that controls this. So there are 3 subsections to this. In the first subsection, it says where the relations subsisting between parties are such that one party is in a position to dominate the will of the other. In section 2A, it says that real or apparent authority over the other or where he stands in a fiduciary relation to the other. Subsection 3 shows that the burden of proving that the contract was not induced by undue influence shall lie upon the person in a position to dominate the will of the other. Under Malaysian undue influence, there is no clear-cut distinction between actual and presumed undue influence like there is in English law based on section 16. All 3 subsections of this section are on the basis of existing relationships of this party. However, the Malaysian courts have adopted the position that section 16 in substance adopts English law as it stood when the Indian Contracts Act of 1872 was passed. The Malaysian courts have not placed too much emphasis on whether or not undue influence was actual or presumed like the English courts.
Lord Nicholas in the Church stated that actual undue influence comprises over acts of improper pressure or coercion such as unlawful threats. Actual undue influence overlap with but fall short of duress because there is practical alternatives. Pressure applied is not illegitimate, but it might still be considered inequitable to uphold the promise. The element of actual undue influence is laid down by Lord Hophouse in A Treat, where the actual undue influence is an equitable wrong committed by the dominant party against the other, and it must be unconscionable for the dominant party to enforce his legal rights against the other party. It is held that the plaintiff was entitled to resign the mortgage because the threat from the banker was for lawful action and so could not amount to duress. However, it amounted to undue influence due to the manner of the threat. There is no circumstances or previous history in which actual undue influence may be presumed. Actual undue influence can be operated for the first time. The victim must prove that there is actual undue influence exerted, resulting in the contract. However, the victim has no burden of proof that there is abuse of confidence and trust in the agreement when illegitimate pressure is applied in the actual influence. There is no requirement of call for explanation or to prove manifest disadvantage in the transaction for the claimant who proved undue influence. Call for explanation is not needed in actual undue influence because it only helps to prove undue influence. It is not needed in actual undue influence as it is already been proved. Originally, the requirement for manifest disadvantage was a requirement that the claimant seeking to find relief must prove there's a manifest disadvantage. In the case, this can be seen in the case of BCCI against the Budi. However, in the case of Royal Bank of Scotland against Utrecht, the court reinforced Pitt and held that proving a transaction that calls for explanation and manifest disadvantage is not necessary for case of actual undue influence. As actual undue influence is a species of fraud, a man guilty of fraud is no more entitled to argue that the transaction is beneficial to the person defrauded. In Malaysia, actual undue influence is said to apply under Section 16, Subsection 1 of Contract Act 1950. It is stated that a contract is said to be induced by undue influence where the relations subsisting between the parties are such that one of the parties is in the position to dominate the will of the other and uses that position to obtain an unfair advantage over the other. In the decision in the case of Pusatura against Kanapa, Chetia against it is stated that both elements of dominant position and unfair advantage must be proven for undue influence to arise in Malaysia. The element of actual undue influence is listed out in this case, where for undue influence to arise, one person must be in dominant position, and the dominant person must obtain unfair advantage, and it is not enough when there is only influence. The influence must also be undue, and the transaction must be unconscionable. One of the distinction, in the case of HSBC against Skype United Leon Enterprise, the second defendant got the plaintiff's solicitor to meet him at coffee house instead of going to plaintiff's office himself when the plaintiff asked him to do so. Therefore, the defendant failed to prove dominant position. Moreover, in this case, it is stated that the lack of independent legal advice did not necessarily point to undue influence. One of the distinctions between actual undue influence in English law and Malaysian law is that the person alleging undue influence has to prove unfair advantage in the transaction. This can be seen in the case of Sogat Bill against Chong Yu Meng, where it is held there is no undue influence because there is no evidence of the transaction being wrongful, and it is not unfair because the defendant kind of obtained advantage in the transaction. Another distinction between English law and Malaysian law is that dominant party has the burden of proof to show that no actual undue influence is exerted. It is stated in the Section 16, Subsection 3 of Contract Act 1950 that where a person who is in a position to dominate the will of another enters into the contract with him and the transaction appears on the fact of it or on the evidence adduced to be unconscionable, the burden of proving that the contract was not induced by undue influence shall lie upon the person in a position to dominate the will of another. In the case of Rakuna Prasad against Saju Prasad, Lord Shaw stated that even if the transaction had been unconscionable, a remedy does not arise until the initial fact of a position to dominate the will has been established. In this case, the defendant took a loan with a very high interest from the plaintiff upon security of mortgage and contended that the mortgage was due to undue influence. It was held that the relationship between defendant and plaintiff was simply that of lender and borrower, that there's no dominant party in the transaction.
Clause 2A, presumed undue influence, applies whenever the party claiming it can show a relationship of trust and confidence, which is the fiduciary relationship, with the party against whom the undue influence is alleged. And the claimant needs to prove only the relationship, and once undue influence is presumed, the other party knowledge of its character and effect. To achieve this, defendant need to show that the other party had the benefit of independent, impartial advice before entering the contract. Fiduciary is defined in Bristol and West Building Society against Morphew, 1998, Act 18, per Millet, Lord Justice. It says, a fiduciary is someone who has undertaken to act for or on behalf of another in a particular matter in circumstances which give rise to a relationship of trust and confidence. And it must be obligation of loyalty, and when relationship of trust and confidence arose, the fiduciary must act in a good faith, and the principal is entitled to the single-minded loyalty of his fiduciary. Presumed undue influence can occur in certain relationships such as parents and children, spiritual advisor and follower, doctor and patient, trustee and beneficiary. However, this does not include husband and wife nor employer-employee relationship. Although there is no class 2A presumption of undue influence as between husband and wife, it should be emphasized that in any particular case, a wife may be able to demonstrate that in fact she did leave decisions on financial matter to her husband, thereby bringing herself within class 2B. That the relationship between husband and wife in particular case was such that the wife reposed confidence and trust in her husband in relation to financial matters, and therefore undue influence is to be presumed. In Lancashire Loans Co. against Black 1933, this case illustrates an example of mother and daughter relationship. The court accepted that the daughter was dominated by her mother. The daughter did not properly understand the nature of the document she was signing, and the daughter had been given no independent advice. And this is one of the examples of Class 2A presumed undue influence. In Alcott and Brigade Skinner is where example of spiritual advisor and follower. Here, a woman belonging to a religious sect was persuaded to give all of her property up to the order. Although her action failed because she waited until 5 years after leaving the order before claiming, however, the court was happy to accept that a presumption of undue influence might arise in such circumstances. Bank against Bundy, Lord Denning felt that the presumption should apply in any situation where there is any inequality in bargaining strength. In this way, the presumption might cover certain transactions occurring in relationships that are actually expressly excluded from the presumption, such as banker and client. It stated, per Lord Denning, in a vast majority of cases, a customer who signs a bank guarantee or a charge cannot get out of it. Yet, there are exceptions to this general rule. There are cases in which a court will set aside a contract or a transfer of property when the parties have not met on equal terms. When one is strong in bargaining power and the other so weak that as a matter of common fairness, it is not right that the strong should be allowed to push the weak to the wall. I think that the time has come when we should seek to find a principle to unite them. However, Lord Scarman in National Westminster Bank Public Limited against Morgan had rejected Lord Denning's notion. It stated, an unequal bargain will, of course, be a relevant feature in some cases of undue influence, but it can never become an appropriate basis of principle. This type of transaction, such as a relationship of trust and confidence between the father and bank manager, is more appropriately now be covered by Class 2B, which will be discussed later, and subject to various requirements of that class. In Malaysia, Class 2A undue influence, it's quite similar to the English law, and they also have to prove special relationships according to Public Finance Berhad against Libby Rubber Factory. And the relationships are such as solicitor and client, doctor and patient, guardian and a ward, a person in local parentage and his charge, a man and his fiancée, and etc. The plaintiff only has to show that there was a relationship of trust and confidence between him and other party, such that it must be presumed that the other party abused the relationship to procure the contract. So this is quite similar to the English requirement. And once the relationship is proved, burden shifts to the other party to rebut the presumption by calling evidence to the contrary. Cheng Bok and others against Ko Cheng Poon and others. This case is quite similar to the case in Lancashire, the English one. This is the case of the deceased father had been induced by his son into making certain gifts to himself. As the deceased was totally dependent on the son, undue influence could be presumed under section 16, subsection 2a. One of the requirements under section 16 of Malaysian law is one party must be in a position to dominate the will of the other party. And although the case of Manu Singh against Muhammad Pandit is similar to Alcott against Skinner, it can be distinguished as the spiritual guru induced the plaintiff, his devotee, to give all his property to secure benefit to his soul in the next world. And it was withheld by the court that such a contract is void as the consent was obtained by undue influence. Whereas in Alcott against Skinner, the spiritual mother showed that the property was transferred willingly. The spiritual mother did not induce or ask her to transfer any of her property. Basically, it's like she did it by her own will.
Cases of presumed undue influence are relatively more difficult to classify. The essential idea is that one party has taken advantage of a relationship of trust and confidence to the substantial detriment of the party who has reposed the trust and confidence in him. However, it must be noted that the requirement of substantial detriment has been replaced and will be discussed in a later slide. And this change has also been recognized by the Malaysian courts. Thus, the case with Class 2B presumed undue influence is, as Sir Gunter Trattel noted, in whether one party has reposed sufficient trust and confidence in the other, rather than whether the relationship between the parties belongs to a particular type. Therefore, if the relationship of the case of complainant or claimant does not fall under Class 2A, which was mentioned by my colleague, it may fall under Class 2B, provided that the complainant can prove an actual existence relationship of trust and confidence reposed in the wrongdoer. The list of relationships are infinitely various, and whether if there is a relationship of trust and confidence will be of a question of facts. However, in Malaysia, even though there is no clear categorization between Class 2A and Class 2B made in Section 16 of the Contracts Act 1950, the courts have recognized the English approach of creating new relationship of trust and confidence, and it doesn't fall under Class 2A. And the list of relationships is not exhaustive, as aforementioned, and is unlimited. As long as in all circumstances of the case, there was a relationship of trust and confidence. The emphasis is on trust and confidence. Then, the influence by the wrongdoer will be presumed. However, in the case of husband and wife, the court in both English and Malaysian cases have been reluctant to place it under Class 2A, but put it under Class 2B. Therefore, for every cases, when there is involvement of husband and wife, the spouse will have to prove relationship under Class 2B. And this is recognized in the case of Public Finance Berhad and Lee Rubber Factory Sdn Berhad in 1994, which held that no presumption of undue influence arose by reason of husband and wife relationship alone. Therefore, in order to establish presumed undue influence under Class 2B, two elements must be proven by the claimant. First, there must be a relationship of sufficient trust and confidence between the parties, and once this has been proven, influence will be presumed. Secondly, the transaction that has taken place between the parties must not be explicable in terms of ordinary motives on which ordinary people act. In other words, it must be so unreasonable that it has to be called for explanation. The Malaysian approach is the same as the English, as it is under Section 16(1) of the Contracts Act 1950. It expressly requires the presence of unfair advantage to the wrongdoer. The reason for the presence of unfair advantage is because, as noted by Lord Nichols in Ipswich, saying undue influence typically occurs when one person places trust in another to look after his affairs and interests, and the latter betrays his trust by preferring his own interest. He abuses the influence he has acquired. Thus, the equitable action of undue influence places regard on defendant action rather than the claimant being unduly influenced. Prior to Utrecht, the customary requirement of manifest disadvantage was an essential element that the sufferer of the contract has to prove in order to establish presumed undue influence, and this requirement was applied by the Court of Appeal in Bank of Creative and Commerce International SA and Abu. However, the test of manifest disadvantage has been overruled due to the House of Law decision in CIBC Mortgages NP. And on top of that, this overruling decision has been supported by Lord Laker's judgment in Utrecht, citing the judgment of by Lord Justice Lingley in Orcastina, saying the gift must have been so large as not to be reasonably accounted to on the ground of friendship, relationship, charity, or other ordinary motives on which ordinary men act. In Malaysia, the modern approach of the second element was recognized by Justice Visu Sinadurai in polygram brackets Sendirian Berhad and Search in 1994. Yet, the test of manifest disadvantage was nevertheless applied, and in fact, the failure of the defendant to establish manifest disadvantage has disallowed them to set the contract aside. Therefore, this case shows that the requirement of manifest disadvantage, although unimportant, the courts will still take the factor into consideration in presuming undue influence in order for the court to reverse the burden of proof to the dominant party. Once these two elements have been proven, a rebuttable presumption of undue influence will arise, and the onus of disproving falls upon the defendant, as per Lord Nichols stated in Utrecht, to establish undue influence, prove that the complainant placed trust and confidence in other party in relation to the management of the complainant's financial affairs, coupled with a transaction which caused for explanation, will normally be sufficient, failing satisfactory evidence to the contrary to discharge with the burden of proof.
So, it has two classes, class 1 which is actual undue influence and class 2 presumed undue influence. Under presumed undue influence, there is class 2A, which is wrongdoing party has exercised a dominance over the innocent party, and class 2B, which has a pre-existing relation of trust between the parties in a contract. So, for the Malaysian side of undue influence, Malaysian side of undue influence is governed by section 16 of the Contracts Act 1950. Also, two classes. First, actual undue influence. Second, presumed undue influence. Again, another 2A, relationships which are in position to dominate the other party, and 2B, existence of trust and confidence relationship in the dominant party towards the innocent party. So, first of all, what is similar between Malaysian and English? To conclude, as a Commonwealth country which was ruled by the British, it can be said that normal principles are applied as English common law on the doctrine of undue influence. In our country, there exists a Contracts Act 1950, and it expressly states under section 16, which is the main one governing undue influence, any contract, similar like common law, arises remedies for the innocent party to rescind the contract that was caused by undue influence. Pretty straightforward. It is also vague in the scope of special or fiduciary relationship between parties, and it caused many arguments from time to time, and it has no clear-cut distinction of what was stated. Okay. Now, for the differences, in class 2B, undue influence cases in our country, the claimant must prove two criteria. First one, the existence of trust and confidence relationship between the parties, along, this is the first requirement, along with the free will of the innocent party dominated by the wrongdoer in the formation of the contract for undue influence to succeed. But bear in mind, for common law, only one criteria shall we need to prove for undue influence, which is the existence of trust and confidence relationship between the parties only. It can be said that Malaysia has a more rigid approach towards undue influence. As to prevent the common occurrence of floodgates, Malaysian jurisdictions also take into local consideration accounts, for example, customs and policy issuance, which judgments of the courts differ on case-by-case basis of facts. But as we all know, English jurisdiction is following common law, which the doctrine of precedence prevails, and for the scope of doctrine on undue influence is therefore very predictable as it follows the precedence. So, lastly, our group states that for the remedy of the cause, the principle laid down on the given topic, which is undue influence, shall be more flexible and be decided by the facts of each case, rather than following vague principles which the outcome may be different by each judges who are deciding the case in court. Therefore, no unjust will arise if it is dependent on case-by-case basis. Therefore, thank you.